Hello, doctors. I'm Dr. Chris Rapoff of QME Continuing Education. Welcome to this week's Case Law Update. In today's case, I bring you an interesting issue that is rarely ever considered, and it's namely the coming and going rule. And when you assess an AOE COE issue to determine whether or not an employer is liable, coming and going in reference to when the applicant was coming to work, they were involved in an incident, or maybe when they were leaving work, they were involved in an incident. Is the employer liable? Well, let's see what the appeals board has to say in a specific ruling on a reconsideration request. So in this case, we have a defendant is seeking reconsideration of a workers' compensation judge's ruling where the applicant, in this case Ms. Duran, was actually hit by a car while she was waiting on her employer's premises for her ride home. And also Mrs. Duran spent time waiting for her ride home on this property before the accident occurred. They determined that this was within the course and the scope of her employment. So they indicated that AOE and COE question was met. Now, of course, we have the defendant stating something different. In their case, they said Ms. Duran's injury, in their opinion, did not occur within the scope and the course of her employment, and that the, quote, general premises liability rule doesn't apply because Ms. Duran was acting in her self-interest with no benefit to her employer at the time of her injury, and that Ms. Duran's injury occurred while she was, quote, going home. That's their contention. Now, just to reiterate, the work comp judge's initial ruling was that in their findings of fact, they found that Ms. Duran's time spent while she was waiting for her ride to take her from work before the accident occurred was well within the course and the scope of the employment, AOE COE. This is where the defendant says this is not the case and they choose to prove otherwise. Now, in the defense's argument, the first argument they mentioned was that an exception to the general premises liability rule applies in this case. They contend that the act of waiting for a ride home is solely in the applicant's own self-interest with no benefit from the employer or to the employer. In this case, then, the defendant cites several cases, which you can read and read about in this case, in support of their argument. But many of these cases involve employees who entered their employer's premises for personal reasons, such as maybe picking up a paycheck on their day off, or as another example, an employee returning to the employer's premises 4 or 5 hours after their shift ended to pick up their husband's keys. In response to that, the appeals board basically said that the common thread with what they cited in those other cases is that the employees enter their employer's premises for personal reasons and not in a furtherance of their job duties or their employer's interests. Now, this differs from the case at hand. In this case, Mrs. Duran entered the employer's premises to work and was involved in an accident while waiting for her ride home after her work shift ended. There was no evidence provided to suggest that Ms. Duran left the premises after her work shift ended, but before she was hit by the car. Now, once again, the defendant was not holding back and cited several other examples of circumstances in which an employee was not considered on the job when they were injured. And again, the appeals board argued that the defendant's contention was a misguided argument, as Ms. Duran had not yet begun her commute home, so therefore she was on the premises and therefore she was injured on the job. And the appeals board sought the big guns in this case and cited a California Supreme Court ruling. And this original ruling, which again you can read about in this case, states that prior to entry, so before you get into work, going and coming rule ordinarily precludes recovery. So before work, it's not necessarily considered at work. But after you enter your workplace, injury generally is presumed compensable as arising in the course of your employment. And this applies in Mrs. Duran's case. So the employer's premises include the parking lot as well as the plant or the office. And once the employee has reached the premises, employment is not interrupted by crossing public property while traveling from one part of the premises to another. It gets a little wonky there, but they are making sense. Now, this so-called premises line that the Supreme Court refers to, they say basically has an advantage of enabling the courts to ascertain the point at which the employment begins. And they say it does that objectively and very fairly. So the applicant, Ms. Duran, was hit by a car while waiting for her ride home in the employee's break area on the employer's premises. As such, they concluded that the going and coming rule is not applicable to the facts of this case at hand. So what do you think the ruling was? So based on those court cases and the information that the appeals board cited, and especially the premises line subject and decision by the California Supreme Court, their final recommendation for reconsideration by the defendant against Ms. Duran was denied. Well, once again, doctors, I hope you enjoyed this week's presentation. Today's ruling clarifies when the employee-employer relationship physically begins and actually when it ends, in reference to the coming and going rule as we consider AOE-COE and when we opine for or against an applicant's industrial injury. This ruling is just another example of the complexities involved in the realm of work comp laws as we understand them. I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time again to join me in this presentation. I hope you enjoyed it, and I look forward to sharing another interesting case again with you very soon. Thank you.